first presentation will be made by Valentina Bonini from University of Pisa, and she will present the country report of Italy. And dear Bonini, you have 30 minutes for your presentation. Then we will move on to the 15-minute question and answer section. In this regard, I would like to remind that, dear participant, you can write your question in the chat during the Ms. Bonini's presentation. The floor is yours, Ms. Bonini.
Thank you very much. Thank you. I will try to share immediately my presentation. And I promise I will try to be very quick, even if the questions are so many. First of all, good morning to everyone. I'd like to quickly express my gratitude to the organization, not only for having involved me in this amazing event, but above all for the decision to dedicate the 9th edition of your Law Summer School to the Istanbul Convention in such a delicate 10th anniversary of the convention. And I'm going to present you the state of the Istanbul Convention implementation in Italy, starting with a basic consideration. Italy put its signature to the Istanbul Convention on 2012 and ratified it a year later with the Law 77 of 2013, so becoming a party to the convention prior to its entry into force. Officially, no reservations were made at the time of the signature, but it had been presented an interpretative declaration stating that Italy declares that it will apply the convention in conformity with the principles and provisions of the Italian constitution. So it was not properly, technically, a reservation in the meaning of Article 78 of the Istanbul Convention, because it didn't set any conditions for Italy's accession to the convention. However, the broad and some way obvious statement is worth some clarification. During the preparatory work for the first proposal of a ratification law, the political resistance underlying the interpretative declaration clearly emerged, because in that occasion it was observed that the definition of gender and its relevance in the context of domestic violence had no recognition in the Italian constitution, where only equality between sexes and not between genders is expressly provided in Article 3. But I have to remind you that the Italian constitution was written in 1948, when the word gender was far from being within the debate. Anyway, before that first ratification proposal had been approved, the change of the political framework after the elections at the beginning of 2013 led to a new proposal for the ratification itself, and this new proposal became the Law 77 of 2013 with a simultaneous withdrawal of the interpretative declaration, which has no relevance at all. However, it must be said that the Italian debate on gender theory is far from being overcome, as right in these days, the Italian parliament is deeply divided while the discussion is in progress on the so-called Zan's bill. Zan is the name of a senator who presented the proposal, which is a proposal to introduce in the criminal code the crime of discriminatory violence motivated by both sex and gender. So the issues is still in the center of a political debate. But looking at the definition of a phenomenon we are talking about, I have to say that in Italy, there is not a legal general definition of domestic violence and violence against women, as the criminal code doesn't contain a section specifically dedicated to these forms of violence or specific crimes incrimination, as we'll see shortly. So currently, the only official definition of gender-based violence and domestic violence is offered beside the Istanbul Convention by the European Directive 29 of 2012, establishing minimum standard on the rights, support, and protection of any victim of crime. That is a binding document for all the states which are members of the European Union. And at point 17 affirms that violence that is directed against a person because of that person's gender, gender identity, or gender expression, or that affects person of a particular gender disproportionately, is understood as gender-based violence. And it is moreover specified that it may result in physical, sexual, emotional, or psychological harm or economic loss to the victim. Looking at the Italian context, we have only the case law and the case law of the High Court, particularly the Grand Chamber of the Court of Cassazione, that has clarified that within this criminological area of domestic violence, every kind of violence, psychological, physical, moral, sexual violence is relevant. As violence against women is not expressly defined nor treated like an autonomous form of crime, there are not legal provisions or systematic choices which underline its structural feature and its cultural dimension. In front of the severe criminal response to crimes, because the penalties are very high, there is not full awareness of the link between gender-based violence and inequality between women and men. A good solution would be to place the incriminating provisions related to violence against women within a specific section of the criminal code dedicated to gender equality or equality between sexes. And this lack of consciousness about the structural features and the cultural roots of gender-based violence produces at least two effects in the Italian landscape. First of all, the contrast against gender-based violence is pursued through law and order actions, while it is underestimated the importance of a cultural intervention to counteract violence within the family and in the couple. And at this regard, I have to recall the Grevio's report on Italy of last 2020, whose paragraph 29, it is observed that the policymakers in Italy have to date privileged policies aimed at criminalizing acts of violence and tackling the inadequacies of criminal law provisions. These, says Grevio, would reflect an approach which tends to consider violence against women restrictively as an issue of law and order rather than a violation of women's human rights, and in so doing fails to fully recognize the structural dimension of the phenomenon. Moreover, gender stereotypes are often still present both in the press and media's approach to cases of femicides or sexual violence and in the judiciary context. The insufficient training of legal professionals, judges, prosecutors, police, lawyers on gender-based violence issues and features is an important hurdle to the eradication of prejudices from the courtrooms, so that gender stereotypes are still used too often while examining the victim, especially victims of sexual violence and of domestic violence, thus causing secondary victimization. Sometimes the gender stereotype is so deeply rooted in the culture of the judge as well, that it even surfaces in the sentencing when the victim's reliability is assessed. So in the recent decision of the European Court of Human Rights in the case JL versus Italy of 27 May of 2021, has been declared the violation of the positive obligation inherent Article 8 of the European Convention of Human Rights because of the secondary victimization of a victim of gang rape on accounts of the comments in the reasoning of a judgment that were guilt-inducing, moralizing, and conveyed sexist stereotypes. As I already said, the Italian lawmaker chose not to envisage gender-based violence tailored crimes, just as it didn't introduce crimes that have exclusive reference to domestic violence, nor that can be perpetrated only against women. Gender-based violence is rather persecuted by punishing various crimes which are structured, built as general crimes. It has crimes that can be perpetrated indistinctly against any victim, women and men, and in any context, not only within a relationship or within the family. For instance, the Italian legal system doesn't know the crime of femicide. Moreover, murder, sexual violence, ill-treatment, stalking, injury, and other types of violence and abuse are not provided as crimes specifically perpetrated against women or within an intimate partnership. Therefore, they can be equally acted by a woman or a man against a woman or a man, and they're punished in the same way. There are some exceptions to this gender neutrality of Italian criminal law for some crimes that are structurally based on the female sex of the victim. This is the obvious case of female genital mutilation and of a procured abortion, which is recently modified in 2018, punishing the termination of pregnancy made with negligence or with willful misconduct, with a detention up to 8 years. Despite this frame, this systematic frame, recent laws provide a severe punishment for the most common and important, I could say, for the most iconic forms of gender-based violence, such as stalking and ill-treatment and sexual violence. And this choice is expressly motivated by the Italian legislator due to the criminological context of these crimes. In this sense, for instance, the law 79 of 2019, the so-called Red Code, had the explicit intent to give a stronger and tougher response to domestic violence and violence against women. However, though the gender neutrality of the incriminations, despite the gender neutrality of incriminations, most of these crimes are subjected to an increase of penalty up to 1/3 or up to half when they are committed against a family member or a person living with or linked by an intimate relationship, even if a cohabitation or the relationship have ceased. Thus, crimes such as sexual abuse, ill-treatment, stalking, injury, threats, murder, and attempted murder are punished with a more severe penalty when perpetrated in a domestic context or in an intimate partnership. That's the solution chosen by the Italian lawmaker in order to give a stronger response to domestic violence, even if no aggravating circumstances are specifically related to the victim's gender or sex, except for some special provisions which are referred to the woman who is pregnant. Therefore, we can conclude that from a legal point of view, what is relevant is the domestic or intimate context and not the victim's sex or gender. Nonetheless, this legal construction, these legal choices, there is anyway a full awareness that these crimes are committed disproportionately against women. Many special provisions are envisaged when the proceeding concerns one of the crimes typically expressive of domestic violence and sexual violence, especially ill-treatment, stalking, sexual violence, and injuries perpetrated in a family context. Since the need of a quick response from judicial authority is considered important to stop violence and to protect victims, the investigation phase must be opened promptly and conducted with due diligence and without any delay or stasis. In order to counteract some resistance that sometimes police and prosecutors have, as it has been sadly highlighted by the European Court of Human Rights in the decision Talpis versus Italy of 2017, it has been approved the so-called Red Code law in 2019, which has provided that when the police get a report of ill-treatment, sexual violence, stalking, injuries, have a duty to inform the prosecutor immediately, while the ordinary rule is that the police must inform the prosecutor without any delay, meaning to let the police, in all the other cases, a reasonable time to verify the information, and this could lead to delay in involving the prosecutor. Secondly, when the police is delegated by the prosecutor for some investigative actions, they must be carried out without any delay and promptly reported to the prosecutor itself. At last, when proceeding for the same crimes, the prosecutor must summon the victim to make her statements within 3 days from the complaint in order to make a quick risk assessment by hearing the victim's report. The purpose followed by the legislator in 2019 is to create a speedy track for the investigations into crimes more directly expressive of gender-based violence and domestic violence, so as to avoid undue delays that can jeopardize the victim's protection and create a climate of impunity. There are some other procedural solutions that are worth to be underlined, and they have regard to the victim's right to information. That we'll come back later on this aspect. Still having regard to the phase of investigation and the criminal law solutions, some minor offenses, such as threat and injury, can be prosecuted only if a victim's complaint has been promptly, within 3 months, presented, and the victim is always allowed to withdraw it with effect of a dismissal of a proceeding or an acquittal if a trial already started. For some major offenses, such as sexual violence and stalking, well, they can be prosecuted only following the victim's complaint as well, but once it has been presented, cannot be withdrawn anymore. This is an intermediate solution, a balanced solution favored by the Italian lawmaker in order to let the victim free to choose whether face or not the criminal trial for facts concerning her most intimate sphere. But on the other hand, the irrevocability of a complaint protects the victim from being exposed to threats or to manipulations which are part of a cycle of domestic violence and often occur due to the imbalance in the relationship between victim and perpetrator. In the report on Italy of 2020, Grevio urged the Italian authorities to amend this legislation to make it conform with the rules set by Article 55 of the Istanbul Convention related to ex parte and ex officio proceedings. And the Italian legislator answered to this concern with the Law 69 of 2019, providing for a longer term for the victim's complaint in case of sexual violence. Actually, Article 609 septies establishes that the complaint can be filed within 12 months from the time the offense was committed, and it has reiterated that it cannot be withdrawn. One of the pivotal victims' needs is to get protection from domestic violence, and the Italian legislator has implemented many different tools to reach this aim in the civil proceedings, in the criminal proceeding, and with some preventive measures too. Having regard to private law measures, since 2001, with the Law 154 of 2001, it is possible to apply a protection order in case of domestic violence, both in the civil and in the criminal proceeding. The protection order adopted by the Tribunal for Civil Matters can be requested directly by the victim when the partner as behavior that is seriously detrimental to physical or moral integrity or to the freedom of the victim. It is not necessary that a complaint has been filed, but this protection tool is applicable only in case of cohabitation, marriage, or other forms of cohabitation between the perpetrator and the victim, as the judge orders the removal from the family home, a stay-away order, also prescribing, but only as accessory measures, a ban on approaching the places frequented by the victim, and an obligation to pay a maintenance allowance for family members who remain without sufficient income. Looking at the criminal procedure side, several are the measures that can be adopted during the criminal proceeding in order to protect the victim of gender-based violence and domestic violence. Some of these measures are general ones, while others are specifically shaped for domestic violence and intimate partner violence. There are, from a broad point of view, there are two risks considered by the system: the risk of repeated victimization and the risk of secondary victimization. In the first perspective, the criminal proceeding is the place where the victim can find protection from the danger to suffer new offenses from the perpetrator. We say that it is a protection within and by the criminal proceeding. Before the formal opening of a criminal proceeding, the victim of ill-treatment, stalking, and injuries in the family context can ask for a warning that the public authorities adopt, specifically the chief of the local police, the so-called questore. And it is a warning by inviting the perpetrator to refrain from repeating harmful conducts. This is qualified as a soft preventive measure, and it's based on the mere dangerousness of the perpetrator, while no factual basis related to the assertion of guilty is requested. In a similar perspective, because it is a preventive measure as well, can be applied not before but after the end of a proceeding and at the end of a penalty, a special surveillance to the author of domestic violence, stalking, and ill-treatment that is still considered dangerous. But in this case, the protective measure is adopted by the judge because of a limitation of the freedom that can be ordered with this special surveillance. Pending the criminal proceeding, it is possible to apply various protection tools in order to limit the accused's freedom with a different intensity proportionated to the different danger, to the different risk of reiteration of the crimes. In case of flagrante delitto, in the act of the commission of a crime, the police can arrest the perpetrator or remove him from the family home with a stay-away order, and an immediate validation of a judge is required within 96 hours, otherwise expiring the measures. Since the investigation phase is open and all the trial long, precautionary measures can be prescribed by the judge following a prosecutor's demand, with a stay-away order in the form of obligation to leave the family house or prohibition to approach the victims, their relatives, and the places frequented by the victims. Protection orders may be applied also in cases of some minor offenses, such as minor injuries and threats, because they are considered spy crimes, clue of a violent context within the family. Otherwise, for the most serious aggressions and for the danger of greater intensity, it is possible to apply to the accused a pretrial custody in prison. Regarding the danger of secondary victimization, the criminal proceeding is the place where the victim encounters the risk to renew the offense for the crime that she already suffered. We say that there is the need of a protection from the proceeding, meeting the accused in the courtroom area, answering the questions about what happened, being scrutinized to verify her credibility, are all events that may produce secondary victimization. At this regard, the Italian system provides that any statement that the vulnerable victim and the victim of stalking, ill-treatment, sexual violence as well, is requested to make during the investigation must be conducted with the assistance of a psychologist. Then, in order to reduce the number of statements requested to the vulnerable victim, it is envisaged that during the investigation, the victim's witness can be formed in ways that make it available, validly usable as evidence also in the trial, through an evidentiary hearing during the pre-trial investigative phase. On the occasion of the victim's witness, both in the evidentiary hearing or during the trial, Specific measures can be taken to avoid any eye contact too, with the accused, to limit the trauma connected to the entry in the courtroom, and it is particularly important during the witness of child victim, and to counteract the natural aggressiveness of the parties in the management of the cross-examination, prescribing that the judge proposes to the vulnerable victim the question previously elaborated by the prosecutor and the defense attorney. Moreover, when proceeding for sexual abuse and sexual violence, it is forbidden to ask the victim questions concerning her private life or her sexuality if they are not necessary to ascertain the facts. This provision means to avoid making the victim's witness an occasion of victim blaming, using gender stereotypes to introduce moralistic judgment on the woman. We have already briefly seen which are the competent authority to implement the measure, and which is the role of a prosecutor in taking this measure. I only want to remind that in the Italian criminal procedure system, the prosecutor is the chief of the investigation, but being a party, even if a public one, to the proceeding, cannot be entitled to limit the freedom of the accused. In this frame, the prosecutor has a pivotal role in ensuring a timely initiation of the investigation, an efficient investigative activity of the police, a prompt hearing of the victim, and an accurate risk assessment, having the task of asking the judge to take protective measures. As it always happens, the human factor is very important in a field where the cultural approach determines a higher or lower level of attention. Thus, there are some highly virtuous experiences, such as in the huge prosecutor office of Milan, and in the small prosecutor office of Tivoli, a small town near to Rome. But let's see which are the victims of the rights in having the rights victims in demanding the protection measure. The victim has the right to demand to the Tribunal for Civil Matters to apply the protection order and to ask the chief of the police to issue the warning toward the accused of stalking, injuries, or ill treatment. When a criminal procedure is open, instead, the victim's need of protection are evaluated by the prosecutor, which is the only one that can ask directly to the judge to order any precautionary measure. Only in one occasion, the victim has the right to let the judge know her opinions and requests, being entitled of specific information and participation rights. And it is provided when a demand to withdraw of a precautionary measure has been presented by the accused. This is the only case in which the victim is directly entitled to refer to the judge. Looking very quickly to the statistic, I have to say that we have there are many different statistical sources. The Italian landscape is, at this regard, wide but a bit confused. A very extensive study and statistical report in which it is possible to read the data both in aggregated and disaggregated way was carried out by ISTAT, Italian National Statistical Institute, on a mandate of the Department of Equal Opportunities. Then, since 2017, it has been set a special parliamentary committee on femicide with a task to analyze and investigate gender-based violence, and it has collected judiciary data, which can be read with many other relevant information and consideration in the final report of 2018 and more recently in the report of 2020. Moreover, even if only since 2020, the Ministry of Interior releases the statistics regarding the most important type of crimes every 6 months, and they can be consulted on the minister website. Finally, we have some unofficial statistic. The DIRE net, DIRA, is an acronym for Women in Net Against Violence. And it is the most active and important women's NGO in Italy. And at the end of every year, releases statistics related to the shelter services in Italy. Speaking about statistics, it could be worth to take a look, a glance on the ones related to domestic violence during the COVID-19 pandemic. During the first lockdown in March, April, and May of 2020, after a first short period of silence, there's been a high increase of the phone calls to the number 1522, the helpline for domestic violence and stalking. And these phone calls had a growth of 73%. At the same time, there's been a significant increase of the number of women asking for help to the anti-violence centers, more 59%. But despite it, the number of complaints and reports to the police has decreased with a minus 43.6% for reports of ill treatment, and with a welcome collapse in the number of femicides of 83.3% as a result from ISTAT statistic. These numbers must be analyzed, but they are the clue of importance to offer free and easy way to communicate in case of risk of violence. Several are the tools given at this purpose. First of all, the well-known, in Italy, well-known helpline 1522, to which it has been added other instruments in the pandemic period. Indeed, during the lockdown, to contrast the outbreak of COVID-19, governments and independent associations have undertaken to design and convey alternative and more adequate tools of communication than traditional channels, making possible to communicate with operators via messages, online chats, application or social networks downloadable on the mobile phone and equipped for the geolocalization to ensure timely support to victims. A general technological service of Italian police, the app UPOL, has been used to allow quick interventions in dangerous situations and to facilitate the collection of complaints from victims that at that time had few occasions to leave their house, were living under control of the perpetrator. Moreover, during the pandemic, the Anti-Violence Center never stopped to be operating and continued to carry out activities both remotely and, albeit with difficulty, in presence. On the other hand, it was very complex, very difficult to maintain the availability of the shelters during the lockdown period because of the rules relating to social distancing. After the first 2 weeks of lockdown, the government invited the local police and the measures of municipality to stipulate agreements to use hotels for this purpose. So it can be said that the first help action kept working in a good way, not leaving women alone, thanks to the technological tools and the availability of the anti-violence centers, such as the police. it must be said that women asking for help referring domestic violence were exempted from restrictive measures, being allowed to move, to go to the police, to services, to shelters, to hospital emergency. On the contrary, the long-lasting closure of the judiciary activity had a great impact in limiting the access to justice and the access to protection orders too. Though these measures were formally available, the stop to ordinary judicial activity had de facto made them unreachable, with few virtuous exceptions in some areas. About the risk assessment, well, I have not many information on these topics, but I can say that in Italy, there are not legal and binding rules regarding the time, the method, and the content of the risk assessment. The National Plan on Violence Against Women of 2017-2020 has set guidelines based on the EFA protocol and on the international SARA's risk assessment. As the national plan contains mere guidelines, it is not always followed by police and legal practitioners, which often are not specifically trained on this issue. Furthermore, it is worth to be underlined that there is no legal provision about when and who has the duty to carry out the risk assessment. Therefore, in many cases, the risk assessment is not conducted at all, or it is conducted in a very partial manner, mainly having regard to the perpetrator's dangerousness. A special track is followed both for the reception, for the acquisition of initial evidence, and for the risk assessment by the medical staff of the first aid that apply the guidelines of the so-called pink code in case of suspected domestic and sexual violence. And this is an activity related to a first, in the emergency consideration, a first risk assessment. Looking at some special measure, special protection and supporting measures for children, I would like to point out that in a general perspective, it must be said that children are considered victims. They are victims not only when the violence is perpetrated directly against them, but also in case of witnessed violence. Every time they assist to ill treatment, realized physically against another member of a family. The relevance of witnessed violence has been stated in Article 572 of the Criminal Code with Law 69 of 2019, and it must be referred to a broad definition of witnessed violence, which is integrated every time the child has the perception that a violence has been committed in the family context, even if the child didn't see directly the violence, the violent action. Beside the protective measures dedicated to all the victims of violence, the temporary or definitive withdrawal of parental can be declared, and a very delicate issue concerns the harmonization between measures adopted in criminal and in civil matters. Also for this purpose, Article 64 of the implementing provision of Criminal Procedure Code establishes that the precautionary measures and the sentence that close criminal proceeding must be sent to the civil judge for the adoption of measures relating to the custody of children. Furthermore, Law number 8 of 2018 provides a series of benefits in support of non-sufficient orphans of domestic violence who can access to special scholarship or training courses, can have a reimbursement of medical and welfare expenses, including psychological support, and a compensation paid by the state for a sum of 60,000 euros can be enlarged. Foster families can receive a monthly sum up to 300 euros. There are some general tools to support victims of violent intentional crimes operating, provided since 2017, but operating only since 2019, with a law about the public compensation, which gave late implementation to the European Directive number 80 of 2004. With special regard to victims of gender-based violence, it is established that the state distributes compensation for the crime of homicide for an amount equal to 50,000 euros, which is raised to 60,000 euros for the orphan of domestic violence, with an additional reimbursement up to 15,000 euros for documented medical expenses. Then there is a compensation for the crime of sexual violence and for other very serious injuries, such as the loss of a limb or of a sense, and for the permanent scarring of a face. For these crimes is given a sum equal to 25,000 euros and an additional sum for medical expenses. In relation to all the other violent intentional crimes, it is provided only a reimbursement of documented expenses, medical expenses, for an amount up to 15,000 euros. Just in these days, with the publication of the Italian official gazette of 20th July, a decree of the President of the Council of Ministers has introduced the so-called income of freedom for women victims of domestic violence, which provides for the payment of a monthly contribution up to 400 euros to women who are facing the escape from the circuit of violence upon verification, following a verification and a certification of anti-violence center and social services. Accommodation in shelters is quite rarely provided by public institutions, local or central ones. More frequently, this is offered by anti-violence center managed by women non-governmental organizations. The women's NGOs are the protagonists, even for the general support services, giving information, psychological assistance, support in the path of escape from violence. And I would like to close, I'm sorry if I've been so long. I would like to close with last question. Do victims trust the judicial system? I think this is a question worth to be answered at the end of this report, because it needs the knowledge of Italian legal framework, and at the same time it is strictly related to the effectivity of the tools given to prevent and protect victims. And the answer must consider that in Italy we are facing nowadays a general lack of confidence in the judicial system due to the extraordinary delay of the proceedings, both in the criminal and in the civil matters, that create a general sense of impunity. In front of this problem, which is particularly felt by domestic violence victims, the Italian lawmaker is used ensuring by providing higher penalties, but this is not a solution it's not a solution fitting the ask of a prompt response to crime. And this is the reason that suggested the Italian legislature, due to the European Court of Human Rights severe judgments, to provide a faster investigation track for the most serious and worrying crimes related to gender-based violence. However, the structure of a system of protection and punishment, only apparently solid, must deal with a cultural delay and a lack of specific training that affects the professional of justice too. This situation leads to the risk of underestimating the violence, the position of the victim and her needs, producing secondary victimization. To overcome these effects and gain the trust of victims so that they can feel safe in entering in a judiciary experience, it is necessary that all the justice professionals, judges, prosecutors, lawyers, police, receive specific training about the structural characteristics and cultural roots of gender-based violence and domestic violence. This would make the courtroom a more welcoming place for victims. And it doesn't mean less impartial or less unfair, but a more efficient process in offering an appropriate response to gender-based violence. The legal answer is obviously pivotal, but it cannot produce appreciable effects whether it is not placed on a ground that has been culturally prepared to receive it. So this initiative are particularly important, and I thank again all of you, and especially the organization of this summer school. Thank you, and I'm really sorry because I'm terribly late.
Thank you very much, Ms. Bonini, for your presentation. Now we are move on to the question and answer part. We got two questions. By clicking the chat button, you may see the questions, but firstly, I need to read the question for recording. The first question is that you mentioned the process of speedy trial step by step, such as the prosecutor had to listen to victim within 3 days. In this regard, my question is related to prosecutor office. Is the prosecutor office specialized in these matters, or is it a prosecutor office that conducts general investigations? And in this regard, is a sanction foreseen for the prosecutor when the aforementioned deadlines are exceeded? Is it question clear? Okay.
Okay. Well, in the largest office of the prosecutors, there are some professionals, some prosecutors, which are specifically trained on gender-based violence and domestic violence, and they work in the vulnerable victims office. But this is not possible in the smallest one. So there is not a sufficient training of the justice professional and as well the prosecutor. Relating to the delay in these victims' hearing or other speedy track provisions, there are not procedural consequences, because it's not possible to provide an invalidation of a proceeding due to the delay in hearing the victim, because it would be a second and more a second occasion to go counter the victim interest. But the delay in conducting the investigation, in hearing the victim, can have relevance in a deontological, disciplinary level. I don't know if I...
Okay, and the other question is asked by the Teresa Bender. Why is such a committed politician like Laura Boldrini, who has a role who was a role when signing and ratifying the international convention, so much hated in Italy by some politicians and or the parts of the civil society. Is she too much feminist and emancipated for the Catholic Italy? What is your impression?
Well, on this issue, the debate in Italy, and I think not only in Italy, is very polarized, and the political debate is very polarized. So in this context, we have unfortunately, sadly, seen many direct attack to single senator, deputies, politicians, and this is one of these cases. Laura Boldrini is a very brave and courageous deputy, not only on gender issues, but for many other topics and political hot themes. My impression is that, unfortunately, this is part of bad politics that nowadays we are living, where the debate is very often, too often, polarized on personal attack instead of discussing about items, about topics, about political ideas and political position. Mm.
Okay, thank you very much. And I close the question and answer part, but before the finishing our first presentation, Adam Süzer,
Yiğit, hello.
hello.
Hello, Bonini. Sorry for my internet. I have a little message for you. Can you read my message, Pınar? Or Yiğit?
I've read it, and I thank you very much for your special words.
Thank you, Bonini.
I am thanking you for involving me and for this collaboration. Thank you very much.
Okusun da kayıtlara geçsin arkadaşlar.
For recording, I will read the Sözer remarks. I would like to thank my dear colleague Valentina Bonini very much for her presentation and support of our law school. Violence against women and the domestic violence exists in every country, so international cooperation is very important in all matters. Dear Bonini, I wish and hope that our joint work on criminal justice and the women's rights will increasingly continue. Okay, I also read it.
And
thank you very much for your participation and great presentation, Ms. Bonini. And dear participant, we will begin the next session in 5 minutes. Please do not leave. And we will move with the presentation of the Cristina Ruiz Lopez. Thank you very much, Bonini, for your participation. See you again.